These are in Bayelsa State, where it is barely a month to the November the 11th governorship election. But in a twist, the candidate of the APC has been disqualified. That's Sylva. But the All Progressives Congress says it will challenge the disqualification of its candidate by the court. The Director of Media and Publicity for APC Bayelsa Governorship Campaign Council, Perry Tukuwei, disclosed that the party has briefed its lawyers to appeal the judgment, and it is confident that the Court of Appeal will overturn the judgment of the Federal High Court. Mr. Tukuwei said the suit that led to the APC candidate's disqualification was filed by a non-member of the party who did not contest the party's governorship primaries. Justice Donatus Okoro ruled that Mr. Sylva, having been sworn in twice and ruled for 5 years as governor of the state, would breach the 1999 constitution as amended if allowed to contest again. The judge also declared that Mr. Sylva was not qualified to run in the November poll because if he wins and is sworn in, he would spend more than 8 years in office as governor of the state. And for more on this development, let's speak with a lawyer, Evans Ufeli, who joins us live via Zoom from Asaba. Good to have you join us. So let me start by getting your thoughts on this judgment and the validity of it in comparison to the prayers and arguments that were brought to the court.
Yeah, the judgment is valid to the extent that it conforms to the constitutional provision of Section 182 of the 1999 Constitution as amended. Sylva have been a governor twice. His second term was obstructed by the Supreme Court judgment. Okay, so he has been sworn in 2 times. And having been sworn in 2 times, he now emerged as the governorship candidate of the APC. And that time he was in PDP and now in APC, but have been sworn in twice. Now, if he's allowed to, like the lawyer of the adverse party contended, if he's allowed to contest this election, if he wins, it will mean that he's going to be sworn in 3 times. And if they go on the tribunal and it's not overturned, it's going to mean that it's going to serve more than the required term by the Constitution. Now, the Constitution cannot be expanded by either political or judicial accident. As a pre-election matter, it is proper that the Constitution is interpreted at this stage effectively to ground the issue of qualification. Qualification is very key. And if you look at the Electoral Act, qualification is both a pre-election matter and a post-election matter. So the court, in its wisdom, handed down this judgment to prevent a constitutional crisis in the future. And this is very critical. I know that Sylva and his team might want to appeal the judgment.
Because they are saying, I just want to give you one of the legal grounds, because you just mentioned that they might want to appeal. They have said they will appeal. And one of the legal grounds they're saying is that those who brought the matter to court are not members of the party, I think that was, and that they did not also participate in the governorship primaries.
Well, the parties, those who brought the, I think one of them contested because he defeated about 6 of them or thereabouts, whom he defeated throughout in the primaries election. But if it turns out that actually those who brought the case, because I know of one person who is in the suit, but if it turns out that none of them actually and those who brought the suit before the court, it will mean that the court have no jurisdiction to have made that judgment, because the Electoral Act, the new Electoral Act only says that if you are not a candidate who contested the election, you cannot question the outcome of that election. So that is going to be another grounds of appeal, okay, and other grounds. But the truth is that the judgment sits on the right frame of law, to the effect that if you allow this to pass, and then you are going to confront it in the future. So the Supreme Court will do the needful in the circumstance, whatever the grounds of appeal is going to be, and whatever is going to be in the brief of both parties. The Supreme Court must, as a matter of necessity, look at what the court the court beneath, that is the Federal Court now, what the Federal Court have done in drawing out that very critical issue of qualification, whether or not he has that. The party have also said that the time within which this court gave this judgment and the time for the election, if there's an appeal, the party will have no opportunity to conduct another primaries to get a candidate to that effect. So there is time is fast spent. It looks like the party is in a closure.
I mean, this will be the fourth consecutive time. We had one in legal issues will rob the APC of its candidacy, whether in Zamfara, whether in Rivers, Bayelsa, twice now. It will be like twice in Bayelsa. But we'll see how this plays out. And, I wish we could talk about the role, what this means, in terms of the role that legal teams the legal team of political parties play. But, I'm told my time is up and we do have to leave it there. Thank you so much for talking to us as always. Evans Ofeli, lawyer.
Thank you.